welcome back to my channel. My name is Joanne, and I can now say that I've just completed my first year of my law degree. I've got another couple of years to go, and you're welcome. So today I want to go through the new filings that occurred and has been all over social media with my thoughts on it. If you follow me on Twitter, hello Terry C, you will see or note that I had some things to say. We learn that Katie Joy is a she's a celebrity journalist, allegedly, and we find out that the reason for the delay in not filing any document was, in one case, it's mentioned father-in-law. In another case, it's mentioned mother-in-law of one of the attorneys acting needed to go to hospital. So there is there's 5 documents here. And so, hello, I haven't seen you in a while because oh, that's all right, Kim. How are you? Hope you're doing well. But you've got personal life does sometimes get in the way of things. My take on this, which is my opinion, is that it is my opinion that the court, because the court has filed a default judgment, that her opposition to it will not go very far, because the court has stated, and if you remember, oh no, Kim. Oh dear, I'm sorry to hear that, Kim. I've been there and I've done that. Let me tell you that's when you realize how strong you are when you face those adversities. I will tell you that now. Just hang in there and take each day at a time. So they've got 2 orders in here. 2 motions in here, and there's an order that they want. In fact, I didn't download the compelling one, but it doesn't matter. Because anyway, we're gonna see. So I've not really looked at these in detail. I read. Oh, do I want to be? I wouldn't be able to practice in the US, Kim, and I haven't done family law. But I'm happy to read over things. If you wanted me to have a read, I'm happy to read over documents. That's what I say to people and give you my thoughts on them. So we're going to have what I think has happened here is they've been so focused on this discovery issue that they've dropped the ball, and now they're scampering to try and recover everything, but it's, that ship has sailed. All right. So this is the document. This is 3 pages long. Yeah, a lot of people give stuff to me, but I always point out that I'm not a lawyer, but I can give you what I think, give you my opinion on stuff or things that you would, that you need to be mindful of. So this is the defendant's memorandum of law opposing an amended scheduling order. Remember, 7M put into the files that they wanted to amend the scheduling order. Now, the reason for this, all right, here's what happened. So what we had, 7M filed the suit. KJ filed a motion to dismiss. 7M, upon realizing that if the motion to dismiss got up, that there was no need to have discovery. However, up until that point, there had been no response from KJ. So they had no idea what documents they wanted. They wrote to the court, asked whether the scheduling order could be amended until after the motion to dismiss occurred. Now, the court said, we've got your letter, but you need to file a motion. So they filed a motion. In the meantime, there's no response from Katie Joy. There's still been no response or no reply. And KJ and her team are trying to make them compel. The other thing that 7M wanted is they wanted some of the documents protected due to the fact that she has a big mouth and would blast everything. And we've seen that. They were very concerned that information that is found in Discovery or released in Discovery would be blasted all over the internet. This is the motion opposing this, okay? That's where we're at. And we still don't have a response to the original lawsuit. Katie Joy has not responded to say, I reject this. However, if it's true, it's the truth defense or absolute privilege or public interest or whatever the defenses are. There's been no defense filed. She's still not defended herself. And the judge in opposing the motion to dismiss stated in her decision that on the face of it, some of the comments could be seen as defamatory. And also, she said that there had been no defense filed. Now, if I had read that and went, oh, I haven't filed my defense, I'd be filing my defense. But rather than file a defense, they're focusing on this. They are focusing on Discovery and the fact that 7M have not followed Discovery. Despite the fact that they filed a motion, they have a motion in play to amend the scheduling order. You can't, and also she filed a motion to compel. Well, the motion to compel would only work if the scheduling order is refused. If 7M wins their amended scheduling order, their motion to compel doesn't work. If 7M loses this, then the motion, of course, they're going to be compelled to do Discovery. You see, it would seem on the face of it that they're trying to jump 4 or 5 hurdles at once. And again, this is my opinion based on the study that I have done to date, and also remembering that I am Australian. And as she would love to point out, I don't know Minnesota law. However, I have been reading up on the statutes, and having a look at this. So this is filed by Katie Joy's team. So this is defendant's memorandum of law opposing an amended scheduling order. So here is what they're saying. Plaintiffs, having missed the deadline to conduct discovery, have asked the court to amend its scheduling order. Defendants oppose this motion insofar as plaintiffs have failed to exercise even the slightest due diligence in preparing their case for trial. Hello, Bo. Yeah. Don't forget, it's on the court file that they wrote to the court. I'm just saying. So it says Minnesota civil procedures laws sets out forth the process parties are required to use in order to prepare their case for trial. And don't forget, the other issue is because the court put the default judgment there, default judgment hearing there. If the default judgment goes through, again, this is all just a waste of time. They need to be fighting. They need to file a defense and be fighting the default judgment. That's where I would be putting my efforts into if it was me. The two big matters. The only way to overcome the default judgment is to put a defense in and say we have a defense and this is what we're going to defend. And then 7M knows what they're going to need for discovery, because at the moment, because she's not filed anything, 7M are at a disadvantage because they don't know what documents she's relying on. All right. So, sets forth the process parties are required to use in order to prepare their case for trial. Within 30 days of the initial due date for the answer, the parties are required to confer with each other and prepare a discovery plan. All right? Councils are jointly responsible to the court for this process. Now, the other thing is, 7M also wrote to KJ's lawyers to ask for it to be amended. And when they didn't get very far, they went to the court. Counsel are jointly responsible to the court for this process. Plaintiffs would have the court believe that it's the defendant's fault that discovery has not occurred. The truth is that plaintiffs failed to engage defendants on the topic of discovery until the deadline for discovery had passed. Plaintiffs have not served initial disclosures as required under Minnesota Civil Procedure Law. Plaintiffs have not served discovery under 33, 34, 36, and they have not identified witnesses they wish to depose. So because Katie hasn't actually filed a defense to it, if there is no response after a certain time, the court then does a default judgment hearing. So she had a certain amount of time after the motion to dismiss hearing to have filed a defense, which is in the Minnesota. Now, it's interesting. Here they say they have not identified the witnesses. They've not identified the witnesses they wish to depose. How do they know who they need to call if they don't know what her defense is? They don't know what she's. If they don't know, I mean, do they need to speak? Do they need to depose her sources? Do they need to depose, who? She's not filed a defense. She's not stated where she's got her information from, because some of that information have come from people. She hasn't named it. So who do they know who they need to call on? Do you understand where I'm coming from? If she's not filed an answer, at the same time, plaintiffs seek to punish defendants by the draconian measure of default judgment when they missed a technical deadline to file an answer. Well, it wasn't the plaintiffs, you dum-dum, it was the court. Notwithstanding the fact that counsel knew full well the defendants intended to answer, had been fully engaged in the litigation, and had always responded properly to correspondence from the plaintiff's counsel. Plaintiffs seek to ask the court to reward the failure to engage in any meaningful act to advance the case under rules of civil procedures or the court's scheduling order pursuant to plaintiff's excuse for not complying with the rules of civil procedure and the court's scheduling order is that they had not been served with an answer. However, rather than ask about the answer, they filed a default judgment. That's because the court put it there, dum-dum. Oh, sorry, I should be professional, shouldn't I? Plaintiffs have now been in possession of the answer for over a month. However, they have still not served initial disclosures required under rules of served discovery. Defendants might object to discovery as untimely, but at least the plaintiffs would have established some good faith in the effort to advance their case. Finally, the defendant's theory of the case has hardly been a secret in that it was laid out in our defendant's motion to dismiss. And it was dismissed. So the defendant's theory of the case has hardly been so their defense, they're saying that they filed the defense in the motion to dismiss, but the motion to dismiss failed. Oh, I'd rather go to the dentist to get tooth pulled. This is, come on. I'm catching up. Oh. So they're saying we don't need to file an answer because we've already outlaid everything in our motion to dismiss. However, the motion to dismiss failed. So what makes you think that if it failed once, it's not going to fail again? All right. Oh, how painful is that, hey? No, I don't think they can do a contempt of court. That's why they did the default judgment, Kim, because you asked, is it a contempt of court? No, that's why the court, after the... It's interesting because we all noticed that there was this default judgment hearing on the court schedule. I thought, this is really weird because there's not been a default judgment filed. And so what's happened, because the default judgment hearing has appeared on the calendar, 7M have gone, okay, well, we're going to formalise it. We're going to put forward all the paperwork for the default judgment. The thing is, if the courts put it in place, then they're going to be arguing with the court and not blaming 7M. Anyway, and they refer to it as draconian. Well, as I said, they need to take up their issue with the court. Right. So here we go. So this is now opposing plaintiff's motion for a temporary injunction. So 7M has filed for an injunction, so that they've said we're happy to comply with discovery. However, only the lawyers can see it. Now, we saw in the filing the other day that the protest was that Katie Joy wasn't going to be able to see discovery. Well, there's a reason why 7M wanted to keep that out of her eyes. Most of the time, discovery is just done by the lawyers. The clients don't get to see them. The lawyers go through it all and work out, because ultimately it's the lawyers that have to fight it. So they know what they're looking for in discovery. So anyway, so this is plaintiff's motion for a temporary injunction must fail because it sets a prior restraint that is prohibited by the First Amendment. Oh, we're using the US Constitution now, are we? Plaintiffs have failed to establish an entitlement of relief under the Dahlberg factors in that plaintiffs are public figures who are subject to intense media scrutiny. I can't even say the next line. Can you read that? Well, actually, it's debatable whether they are public figures, but anyway. While defendant Paulson is a journalist reporting on controversies about plaintiffs that are already matters being reported on by media. I don't believe I've read any media report about human trafficking or waterboarding or anything like that, but hey. Any incremental benefit plaintiffs might gain by silencing a single media outlet is outweighed. She's not a media outlet. Is outweighed by the harm created by the prior restraint that would be imposed upon defendants. Plaintiff have not established the likelihood that they will exceed on the merits of the case. Well, actually, they have, because the judge in her judgment for the motion to dismiss said that it would seem that statements were defamatory. So, come on. Public policy favours supporting defendants' right under the First Amendment, and plaintiffs' proposed injunctive relief poses significant burdens upon the court in that it would be required to ensure the defendant's right to free speech and due process are honoured, even where the plaintiffs have proposed to assume the role of monitoring defendants' compliance with court orders. Plaintiff 7M Inc. is a talent management company representing influencers and other internet and media and television personalities. Plaintiff Robert Shin is the sole owner and CEO of 7M. He is also the pastor of Shekinah Church. We're finally now bringing the church into it. Miranda and James Derrick are clients of 7M who produce social media content. Miranda and James have also been identified as members of the Shekinah Church. What? Oh no! I haven't read this. In recent years, many entertainment news outlets have reported that 7M, Shin, and the Shekinah Church have exerted cult-like control over 7M clients and church members. Prove it. Stories have appeared in the Rolling Stone, the Daily Mail, and Daily Beast, and a number of YouTube outlets. Most recently, there are reports that HBO was producing the documentary on the controversies surrounding the plaintiffs. Family members of 7M clients, including the Derrick family members, have featured prominently in these stories. See Paulson Declaration. Oh no. The defendant, Catherine Mansky Paulson, is a journalist focusing on celebrity news and entertainment stories. Among innumerable other items she has reported on over the last couple of years, Paulson reported on first-hand accounts of personal experiences of dancers and influencers who formerly worked for plaintiffs based on information Paulson has received directly and through other media outlets and court records. Okay, question. You can't report first-hand accounts because a first-hand account is that you've experienced it. Am I correct? If I'm giving you a first-hand account of something, I'm telling you what I've experienced. That says it needs to be Paulson reported, and then she says has received directly through other media outlets and court records, which means she's using hearsay evidence. Really? So what that needed to say is that she got her information from witnesses. But the thing is, as soon as she says that, she's going to have to name them. Exactly, Kim. It's first-hand is I'm telling my story. Paulson publishes her content on channels owned by Without a Crystal Ball LLC. Miss Paulson has a YouTube channel with 262,000 followers and an Instagram account with 88,000 followers. She's regularly cited and reported on in national publications such as People Magazine, In Touch Weekly, The Today Show, US Weekly, and more. Really? Prior restraints of speech have long been deemed unconstitutional except in the most drastic of situations. So there's Nia versus State of Minnesota, in New York Times versus United States. The United States Supreme Court said any prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. And in that shows such a restraint must be necessitated by a compelling governmental interest and whatever that means, narrowly tailored to serve that interest. Plaintiffs have not identified a single governmental interest to be served by restraining the defendant's speech. Instead, the plaintiffs cite 2 Minnesota District Court cases where defendants were enjoined from making social media posts. In Sajay versus Nagar, the parties to litigation had some sort of personal relationship that resulted in the issuance of a harassment restraining order. The plaintiff was an author and lecturer who produced materials related to meditation, spirituality, and self-help. The defendant was a private citizen who had prior history of harassing the plaintiff and his family, creating videos, social media profiles, and documents with allegedly false and defamatory allegations about the plaintiff. Unlike the present case, the plaintiff was not a public figure. Moreover, that defendant was not in the business of producing celebrity news content like the defendants are here. Now, let's just pause there for a moment. Talking about celebrity news content, it's quite interesting that she's going down this celebrity news journalist aspect when she can't talk about the Chrisleys, who are big news at the moment, and she can't talk about the Westbrooks. So, yeah. All right. Finally, the court's decision, while final as to the parties in that litigation, remains untested by an appeal. And then Ludgate versus Affordable Granite and Cabinetry involved a former business associate who threatened to target defendants' employees and published damaging statements about the company if it didn't settle the parties' breach of contract. Breach of contract, breach of implied covenant and fair dealing, bad faith, promissory estoppel, conversion, intentional infliction of emotional distress, and claim of delivery. Once again, there is nothing in that decision that suggests that Ludgate was normally in the business of producing internet news and gossip content. There is nothing in the file that suggests that Affordable Granite and Cabinetry had a status as public figure. The court, in fact, distinguished between private and public defamation, noting that the imposition of liability for private defamation does not abridge the freedom of public speech or any other freedom protected by the First Amendment. The present case is one implicating public defamation and is fully subject to First Amendment protection. Finally, the court's decision, while final as to the parties in that litigation, remains untested. Plaintiffs have failed to overcome the burden to justify the imposition of prior restraints, such that the court should entertain the Dalberg analysis required for issuance of injunctive relief. Now, one of the arguments that 7M did put forward was the fact that she had a big mouth. I mean, they didn't say it like that, but that she would blast contents of court testimony and documentation everywhere. And financial records and all of that. And that's 7M's concern, that all of that financial stuff's going to be blasted. So the Dalberg factors do not weigh in favour of injunctive relief. Before issuing a temporary injunction, the court must apply the factors set forth in Dalberg Brothers versus Ford Motor Company, which include the nature and background of the relationship between the parties pre-existing the dispute giving rise to requested relief, the harm to be suffered by the plaintiff if the temporary restraint is denied as compared to that inflicted on the defendant if the injunction issues pending trial. Could you imagine if 7M actually got their injunction and she couldn't talk about them before the trial? The likelihood that one party or the other will prevail on the merits when the fact situation is in light of established precedents fixing the limits of equitable relief. The aspects of the fact situation, if any, which permit or require consideration of public policy, expressed in the statutes, federal and state, and the administrative burden involved in judicial supervision and enforcement of the temporary decree. A weighing of these factors does not yield conclusion that injunctive relief is appropriate. So now they're going through and looking at each of these factors. So the nature and background of the relationship between the parties does not support an issuance of a temporary injunction. A temporary injunction is an extraordinary, equitable remedy, and its purpose is to preserve the status quo until adjudication of a case on merit. Miller versus Foley. Before this matter, plaintiffs were public figures who produced internet media content. Defendant produced internet gossip and news content. Hang on. I thought she was a celebrity news journalist. Hang on. We're just changing our stuff now. Defendants produce internet gossip and news content. We finally got an admission. She's a gossiper. Oh dear. Defendants produce internet gossip. There you go. There is no contractual or familiar relationship that must be preserved pending resolution of plaintiff's lawsuit. the balance of harm does not weigh in favour of injunctive relief. Defendants have established that the requested relief is a prior restraint that infringes upon their First Amendment's right to speech. Defendants will acknowledge, for the purposes of this motion, only the things... Oh, that's right. Yeah. Defendants will acknowledge, for the purpose of this motion, only that the things being published about the plaintiffs are unflattering, and may lead others to believe unflattering things about the plaintiffs. However, defendants are not the only people saying these things. A Google search of 7M Films Shin yields 4 pages of results from content providers other than the defendants. And we're going to see that when we get to the Paulson Declaration. None of these links are to flattering articles about the plaintiffs. Although the plaintiffs may present one journalist from publishing negative stories about them through injunctive relief here, plaintiffs cannot prevent the rest of the internet from following this litigation, investigating the claims made by the defendants and others, and publishing unflattering articles. Thus, while injunctive relief may yield some marginal benefit to the plaintiffs, overall the balance of harms weighs against imposing a prior restraint upon defendants' First Amendment right. Well, here's the thing. If people are using her as a source, and she's talking about human trafficking and all of that sort of stuff, and there's a link between the articles and her, and it's defamatory, that's more of a problem. Plaintiffs have not shown their likelihood that they will succeed on the merits of the case. Defamation is established where that's right, plaintiff here, and they don't accuse him of human trafficking. That is correct. Defamation. And plaintiff create. They also don't brag about the fact that sponsors are walking away either. Defamation is established where a plaintiff provides that one defamation statement is communicated to someone other than the plaintiff. It was. The statement is false, and the statement tends to harm the plaintiff's reputation. If plaintiffs are public figures, there must be a showing of actual malice defined as publication, while knowing that the statement was false or with reckless disregard to whether it was false or not. Stump pegs and park etiquette. Defendants allege that their statements in question were either true, opinion, or subject to privilege. For the reasons stated in the memorandum opposing default judgment, there is a significant likelihood that the plaintiffs will fail to establish the defendant's reporting constituted actual malice, such that they'll be able to prevail on the claims of defamation. So they're saying we're true, opinion, or subject to privilege. Well, tell us what statement was what. You just can't say allege that the statements in question were true, opinion, or subject to privilege. Which one's which? And anyway, if that's the response, then I'm sorry. Moreover, the defendants have missed their deadline to conduct discovery and may be foreclosed from performing discovery necessary to establish actual malice. It simply cannot be said that the plaintiffs have shown a likelihood they will succeed on the merits of the case. No, but they might succeed because you actually haven't filed a defense. You actually haven't filed a substantive answer as to what is truth and where you got your truth from, your opinion, and how you formed your opinion, and privilege. What's the privileged information? Usually privilege, it should be qualified privilege, because privilege for me would be, hang on, I'm just going to look. Usually it's confidential information, and she would be saying it's witnesses. So we have qualified privilege, which means that so usually it is. So it's like where you've got legal professional privilege, you know. like confidential communications and confidential documents prepared are usually between client and lawyer. So I don't know what she would have that's privileged. Anyway. Public policy weighs against injunctive relief. Oops, let me just put this back up. Defendants cite Milkovich and Lorraine Journal for their proposition that society has a persuasive and strong interest in preventing and redressing attacks upon reputation. Defendants stopped reading a little too soon. The Milkovich court continued. Justice Stewart in Roseblatt put it with his custom. Why are they trying to show that they stopped reading too soon? They're the ones that are on the back foot at the moment, in my opinion. The right of a man to the protection of his own reputation from unjustified invasion and wrongful hurt reflects no more than our basic concept of the essential dignity and worth of every human being, a concept at the root of any decent system of ordered liberty. The destruction that defamatory falsehood can bring is, to be sure, often beyond the capacity of the law to redeem. Yet imperfect though it is, an action for damages is the only hope for vindication or redress the law gives to a man whose reputation has been falsely dishonoured. Far from supporting the proposition that reputational damage should be considered as part of a public policy analysis when considering injunctive relief, Milkovich states for the proposition that money damages are the way to serve a public policy in favour of protecting reputational harm. The only public policy present in this case is that supporting defendants' right to free speech. Administrative burdens involved in judicial supervision and enforcement of the temporary decree weigh against injunctive relief. Plaintiffs post that administrative burdens can be largely borne by the parties themselves. Certainly, defendants expect plaintiffs will continue to monitor Ms. Paulson's every word on the internet. However, the administrative burden is not about monitoring defendants. Rather, the administrative burden lies in ensuring that defendants receive due process should plaintiffs discover any perceived violation of the court's orders. In fact, plaintiffs' proposed order demonstrates these administrative difficulties. The proposed order indicates the plaintiffs want defendants to be enjoined from publishing or republishing on the internet websites, forums, or blogs, social media platforms, or otherwise the following material: that plaintiffs are associated with a cult, that they're engaged in human trafficking, they're involved in theft, engaged in sexual exploitation, the plaintiffs are engaged in torture, statements the plaintiffs are engaged in kidnapping or holding people captive, statement relating to legal proceedings with the plaintiff, statements regarding any relationship between plaintiffs and their business partners, employers, employees, and affiliates, statements regarding marriages of the plaintiffs, or other false and defamatory statements as described in plaintiff's amended complaint. Although this list is extremely long, it is also very vague. Do you find it vague? For example, while it might prevent defendants from stating that the plaintiffs have engaged in theft, it might not prevent defendants from stating that plaintiffs were found to be in possession of property that did not belong to them. Similarly, it is not clear if the plaintiffs seek to enjoin, it should be. Similarly, it is not clear if plaintiffs seek to enjoin defendants from publishing the fact that human trafficking allegations have been made against plaintiffs, or merely conclusionary statements that the plaintiffs have engaged in human trafficking. Only one person's ever talked about human trafficking. Perhaps most concerning is the prohibition against republishing material. The internet is constantly being refreshed. Content is constantly being shared between users and websites. Defendants have control over some of these processes, but not all. A content producer may write about the plaintiffs and link to content previously created by defendants. Republishing the material. Defendants can foresee plaintiffs bringing motions to enforce a temporary injunction, alleging republication where defendants did not seek or intend to republish. Perhaps recognising the administrative burdens posed by the plaintiff's preferred injunctive language, plaintiffs propose that defendants merely put a litigation disclaimer on every social media post video. Hey, that's a good idea. That also poses a significant administrative difficulties on the internet, where content is not always dated or properly attributed. In short, well, we know who doesn't attribute people anyway. In short, plaintiffs' proposed injunctive relief poses significant administrative burdens that cannot be solved merely by plaintiff's assertion that it will be the web police for the court. Defendants are entitled to due process, and it will be the court's job to ensure that due process occurs. This factor weighs against injunctive relief. Because the plaintiffs have failed to establish the Dalberg factors, weigh in support of issuance of a temporary injunction, that would be a prior restraint against the defendant's First Amendment rights of free speech. Right. I think on this matter, I think KJ will have, I don't think that the injunction will succeed. That's just my personal opinion based on that. However, there could be a partial injunction. The judge may decide that she can't talk about it, and then just leave it all over. But for what 7M are asking for, I don't think that they will get all of it. Stranger things have happened. I mean, look, we had a defamation case that occurred in Australia, and all the evidence has been put under seal because it featured a politician and featured allegations of from 30 years ago, and it's all been sealed by the court, so it's never going to see the light of day. So stranger things have happened, and part of the hearings were done in closed court. It could happen. I just don't see it happening. So now we've got the defendant's memorandum of law opposing default judgment. Okay. So, despite the fact the defendants have actively participated in this litigation, including in serving discovery and filing a motion to dismiss, plaintiffs have brought this motion for default for defendants' technical failure to file an answer within 14 days of the issuance of the court's order denying the defendant's motion to dismiss, filed on the 25th of August 2022. It was actually the court that put it there, not the defendants, right? But anyway, yes, they had 14 days and they didn't do it. Plaintiffs brought this suit on March 31, 2022. The complaint as amended on April 5, 2022, alleges defamation per se, tortious interference with contract, commercial defamation, intentional infliction of emotional distress, negligence per se, deceptive trade practice, intentional interference with prospective advantage, and injunctive relief. Instead of answering the complaint, defendants filed a motion to dismiss on April 26, 2022. The court denied this motion on August 25, but did not issue a deadline to defendants to file their answer. Hello? Answer within 14 days. Oh, gee whiz, are they that dense? Their introduction says for the defendants to file an answer within 14 days of the court order, and then they're saying, oh, we never got told when we were supposed to file the defense. Nevertheless, Defendants Counsel executed its answer on September 2, but failed to file the answer. That's not my fault. On the 30th of September 2022, without contacting the defendants or indicating they would be bringing the motion, plaintiffs filed the instant motion for default judgment. On the next business day, counsel for defendants contacted plaintiffs' counsel to request that the motion for default judgment, hello GGB, oops, Post says yes, they are dense. Hello GGB, so good to see you. On the next business day, counsel to defendants contacted plaintiffs' counsel to request that the motion for default judgment be withdrawn. On October 5, defendants served and filed their answer. Plaintiffs never responded to counsel's letter requesting that the default motion be withdrawn. Because... they're still using the old law. And they're forgetting that it was the court that did it, not the defendants or the plaintiffs. The plaintiffs didn't do it. In general, the Minnesota Court of Civil Procedures require that defendants shall serve an answer. No, this is KJ stuff. I haven't checked for 7M. No, she still hasn't responded to the original complaint, Juju. This is my whole argument. And my whole argument is that 7M can't comply with discovery because they don't know what her defenses are. If she says that she's got witnesses or she was told that, for example, if she's saying she's pleading the truth defense for the human trafficking claim, well, 7M's going to want to know how she's come to that conclusion, and they want documents proving that. And then if she says it's a source, well, 7M's going to want to know who the source is. They want to know who they need to call on the witness stand. And how can they do discovery or say who they want to depose if they don't know what she's based her stuff on? Okay, so because defendants filed a motion to dismiss, the answer became due within 14 days of service of notice of the order denying the motion. Defendants missed the deadline. Oh, you admit to it. However, default judgment is appropriate only when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend it within the time allowed, therefore, by the rules of the statute. The court may deny a motion for default judgment if the defendant has a reasonable defence on the merits, defendant has a reasonable excuse for his failure to answer, defendant acted with due diligence after notice of entry of judgment, and no substantial prejudice will result to others. Well, they've still not filed an answer. They're going to use sickness as an excuse. Anyway, all of these four factors must be satisfied in order to justify relief under the rule. And all of these four factors are present here. Defendants have a reasonable defence on the merits. Plaintiff's suit alleges the defendant's social media posts defamed them by characterising a church they are affiliated with as a cult that engages in criminal conduct such as human trafficking, waterboarding, and kidnap. To prove the defamation, plaintiff must prove that the statement was false, it was communicated to someone other than the plaintiff, that it intended to harm the plaintiff and lower them in the estimation of the community. Well, I don't know whether the statement was false, but the fact that they're suing for it, I would assume it would be false. I've not seen any proof anywhere that any of those things are true. It was communicated to someone other than the plaintiff. It was all over social media, and it did harm. Plaintiffs alleging defamation of public figures. They must allege the statements are made with actual malice. Defendants claim that the social media posts in question were either true. Truth is a complete defence to a defamation action, and true statements, however disparaging, are not actionable. Opinion. First Amendment protects statement of opinions in defamation claims, or protected by a public person, a public controversy privilege. A debatable meritless claim is one if established at trial. All right, see ya, Kim. Presents a cognizable claim for relief. Ordinarily, a claim must be established by more than conclusory allegations in moving papers. appellants may establish a debatable meritless claim in an affidavit or other proof. Here, defendants are at a distinct disadvantage in establishing a meritless defence in that the plaintiffs have refused to engage in discovery on defendants. The deadline for serving discovery was August 5, 2022. Since the allegations the defendants have made against the plaintiff has been the subject of intense media scrutiny, Ms. Paulson stands ready to defend each and every allegation as true, opinion based upon true information. Media organisations have examined Ms. Paulson's allegations and independently verified them through interviews and public records. Certainly, Ms. Paulson raised significant factual basis to conclude that her defences of truth and opinions are reasonable defences on the merits. Similarly, Ms. Paulson has raised sufficient facts to establish that has a bona fide and qualified privilege. Ms. Paulson has a YouTube channel of 262,000 followers and an Instagram account with almost 88,000 followers. She's regularly cited and reported on in national publications such as People, In Touch, blah, 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 and more. Ms. Paulson is not the only journalist reporting the controversy surrounding the plaintiffs. Stories have appeared in the Rolling Stones, the Daily Mail, and the Daily Beast. Plaintiffs clearly view themselves as public figures. According to Miranda Derrick, she has 1.3 million Instagram followers and 924,400 TikTok followers. James Derrick has 1.7 million Instagram followers and 4.9. Well, isn't there a test? Wasn't there a test for public figures? That's a famous one. Upon information belief, Robert Shin founded the Shekinah Church in 1994. However, since has launched a record company and production company that has produced a number of Hollywood films before founding 7Ms, which is focused on generating web-based content for TikTok and other such social media. He's been the subject of a number of news articles in multiple publications. Clearly, he is a public figure for the purposes of establishing a qualified privilege. Thus, defendants put forth specific information that established the existence of a meritless defence. So, again, they're saying that based on true information, but yeah, what information? Defendants have a reasonable excuse for failing to file an answer. So here we go. Upon the receipt of the court order, counsel prepared and executed defendant's answer but failed to serve and file it. The failure has two causes. First, counsel was anticipating that the court would issue an order providing a deadline that would be docketed into case management system. Well, that's a bit of a okay. So you want your hand held, essentially. You wanted the court to tell you when it was due, even though you knew you had 14 to 21 days to file it. Second, counsel was unexpectedly called out of the office when his mother-in-law became very ill before he could ensure that the answer was properly filed. That's what you have staff for, isn't it? A third contributing cause, so just remember mother-in-law, okay? Remember mother-in-law, okay? A third contributing cause was that counsel for the plaintiffs did not communicate in any way it would be moving for default judgment if an answer was not forthcoming. While defendants acknowledge that plaintiffs have no obligation to remind the opposing party of its obligations under a rule of civil procedure, it is common courtesy to advise the opposing party of an intent to file a motion, at least to determine counsel's availability. Indeed, the plaintiffs were silent with their motion of default judgment came as a complete surprise. Hello, Callum and Charlie. Complete surprise to the defendant. Hey, we all saw it on the court documents way before 7M filed their default judgment. Counsel acted diligently upon discovering the error. Plaintiffs filed their motion on Friday, September 30, 2022. On Monday, October 3, 2022, counsel sent a letter to the plaintiffs asking them to withdraw the motion for default judgment. On Wednesday, the 5th of October, 2022, counsel served and filed the defendant's answers. Thus, less than 3 business days elapsed. I don't remember them filing an answer before discovering the error and correcting it. Plaintiffs have suffered no prejudice as a result of this error. Plaintiffs cannot possibly claim any prejudice as a result of the 1 month delay in receiving defendants' answer. They were fully aware defendants were actively defending the action. Any doubt could have been resolved with a phone call or email. Plaintiffs volunteered for any prejudice they may have incurred. Defendants have a reasonable defence on the merits, a reasonable excuse for failing to serve and file the answer, and acted diligently immediately upon discovering the answer was not timely filed. Plaintiffs cannot possibly claim prejudice when they did not even pick up the phone. How dare they? Before filing their motion for default judgment. Based on the foregoing, plaintiff's motion for default judgment must be denied. Deny. All right? So, thoughts? It's pretty whiny, in my opinion. All right. This is brilliant. All right. No, it's not 7M. It's not Juju. It's not doing anything. All right, here we go. You ready? We're now going to look at Katie Joy's affidavit. I actually read this on the train and I couldn't actually stop laughing on the train. Okay, everybody sitting down? Catherine Mansky-Polson, being duly sworn, states, I am a defendant in this matter. I make this declaration in opposition to plaintiff's motion for default judgment and a temporary injunction. Well, she's answered the original suit denying everything, but where is her defence? I've not seen a defence plan to create. I've not seen what she's for what argument she's using for truth, what argument. So for each response, she would say, as to allegation of human trafficking, we're pleading truth, or qualified privilege, or opinion. And you're supposed to do that with each statement. That's what we were taught. Okay, here's my classic line. She doesn't cite her arguments well. No, Callum and Charlie, no. I am a celebrity news journalist. Let me repeat that. I am a celebrity news journalist, publishing as Without a Crystal Ball. I have a YouTube channel with approximately 262,000 followers and an Instagram account with approximately 88,000 followers. I am regularly cited and reported on in national publications such as People Magazine, In Touch, Weekly, The Today Show, and US Weekly. See why I laughed, Callum and Charlie, when I read this on the train? Among innumerable stories I have reported on over the last couple of years, I have reported on first-hand accounts of the personal experiences of dancers and influencers who formerly worked for plaintiffs based on information I received directly and through other media outlets and court records. And as I said before, first-hand account is usually the account of somebody that has gone through something. And when someone gives you something, it's a witness statement. Gee whiz. Oh, my lecturers, if I submitted something like this, I could just imagine. Hello, Natalie Rain. The Today Show reported on her one time from a story that she stole about stores. So she's really, oh, really? Oh, dear. I am not the only reporter, here we go, interested in the defendants. Many entertainment news outlets have reported that 7M, Shen, and the Shekinah Church have exerted cult-like control over 7M clients and church members. Stories have appeared in Rolling Stone, the Daily Mail. It's the type of read that had me spinning my tea. Yes, exactly. Exerted cult-like control over 7M clients and church members. Stories have appeared on the Rolling Stone, the Daily Mail, the Daily Beast, the Sun, and Business Insider, and in a number of smaller blogs and YouTube channels. Most recently, there are reports that HBO was interested. Shouldn't it be there are reports that HBO is interested? Why are you using a present tense and a past tense in a sentence? Most recently, there are reports that HBO was interested in producing a documentary on the controversies surrounding plaintiffs. You can't have two different tenses in a sentence. There are reports, but yes. Family members of 7 named clients, including Derek family members, former employees, and numerous other individuals who have personal knowledge, have featured prominently in their stories. Attached as Exhibit A are true and correct copies of some of these articles. A simple Google search of 7M ship films Shin yields 4 pages of results linking to articles that are generally unfavourable to plaintiffs. Attached as Exhibit B is the result of such a Google search performed by my attorney, Jennifer Moore. To the best of my knowledge, defendants are not suing the Rolling Stones, the Daily Mail, the Beast, the Sun. We've got this argument now. Oh, but they're not suing them. They are targeting me because I am small enough to punish through costly litigation. I don't remember Rolling Stone, Daily Mail, Daily Beast, the Sun, or Business Insider talking about human trafficking. I stand by my reporting. My stories are properly sourced using primary sources such as interviews with individuals and court and public records, and secondary. It was my job to go through filings before they were submitted to make sure there were no mistakes, and I just got through opposition to default and floored with the sheer amount of errors. I know, right? Callum and Charlie, with Carly's lawsuit, she was a small YouTuber. With 7M, she's a celebrity. Yes, that's right. I stand, so her secondary sources such as news articles with reliable publications. When I editorialize, I believe my opinion is based upon fair reading of the facts. Reliable sources isn't the Sun newspaper either, by the way. As a journalist, I am accorded significant protection. Isn't it afforded? As a journalist, I am afforded. Shouldn't it be as a journalist, I am afforded significant protection, not I am accorded? As a journalist, I'll read exactly what she's got here. As a journalist, I am accorded significant protection. But what if you would have Googled them in January? Plus, I'm not the only one. Doesn't mean it's... What's that leaving that out? Thank you, Juju. Afforded. It should be afforded, shouldn't it? But we'll read what she's written. As a journalist, I am accorded significant protection under the First Amendment of the United States Constitution. I understand that these protections are not absolute and that a claim of defamation may arise if I make untrue statements with actual malice. My reporting of the plaintiffs is unflattering, but truthful. I do not have actual malice against any of the plaintiffs. I have no personal grudge against 7M Films, Robert Shin, Callum and Charlie. I actually would like to think this was written by Katie because I would be absolutely embarrassed and ashamed if I was a lawyer and I put my name on this. My reporting of plaintiffs is unflattering but truthful. I do not have actual malice against any of the plaintiffs. I have no personal grudge against 7M Films, Robert Shin, Miranda Derrick, or James Derrick. They are simply the subjects of a story that has captured the interest of my viewers. As part of this litigation, I have agreed not to publish contact information for the plaintiffs. I have not published contact information for plaintiffs. I have not agreed to stop publishing stories about the plaintiffs, and I have continued to publish well-sourced stories and fair opinion pieces of the plaintiffs. I declare under the penalty of perjury that what I've stated in this document is true and correct. Okay, so let's have a look. Exhibit A. So this is Rolling Stones. Cult-like. It says cult-like. It doesn't say cult. Cult-like. There's a difference. Oh dear. So that's one story. All right. Now, one of these ones did two sides of the story, doesn't it? I think it was Rolling Stones gave the, you know. So this is the Rolling Stones. But it doesn't say they are a cult. It says cult-like. It's a difference. There's a difference there. To say that it's cult-like is different to saying is a cult. It's about wording. Okay, cultural force that transcends generations. This one here, oh, that's still Rolling Stones. Oh, that's right. She's mentioning that article. Yeah. Well, why have they got all these in here? Okay. Okay. You were trying to obey its congregation that say they were brainwashed by the pastor, now behind the alleged TikTok dance cult 7M. Again, they've used the word alleged. All right? Which is different to what Katie Joy has stated. She's saying, I'm not defending, I'm not saying whether it's true or not. I'm just stating that, and again, Shekinah Church hasn't sued. It's Shin. So everything relevant to Shekinah Church, I can't see necessarily as being relevant because the church, it's about him in his personal capacity, not him in the way of the church, is my point. So I would be arguing that half of this stuff isn't relevant. But again, that's just me. All right. So that's that article. Now, I hope you remember the word mother-in-law for when we get to Graham Cracker's affidavit. All right. And then that's another one. So this is we've still got the same article. So she's trying to prove that. I mean, essentially, I think what she's trying to. No, I don't think so either. And I don't know that you can. I mean, the Sun. I wouldn't call the Sun as a reliable source. Cult Pro TikTok cult again. Cult in brackets later. An investigation by IRS for tax fraud and forcing followers to work unpaid for God. But the thing is here's the problem. Look into any church, and there's lots of unpaid workers. They're called volunteers. Again, I'm not defending him. I'm just stating the truth. Again, this mainly is all on Shekinah Church. This is not on. There's a little bit in here, but again, because Miranda has married James, and we know that's not her. We haven't said anything because. And don't forget the family feud with the Wilkins family and Miranda Derrick is their problem. It's not. It doesn't mean to say it's got anything to do with 7M. Controversial influence company 7M Films examined in HBO Max docuseries from Campfire, Rolling Stones. So they're saying they're going to be okay. Rolling Stones dove deep. Gee, they've not done a good printout of this either. It's horrible. You can't use the defense that everybody else is talking about it, so why should you go after me? Then this is Exhibit B. This is the Google. So this is Google search. So that's the Sun, Business Insider. Inside the cult claims surrounding Miranda Derrick. Controversial influence. Oh, look, Meghan Markle starting movie produced by Robert Shin. Meghan Markle offered once. Oh no, she was in the cult. I was swindled out of $4 million by alleged TikTok cult. And again, they've used the word alleged. TikTok star's family concerned daughter's been held hostage. Again, well, we know that that's a family dispute. Okay. So, counting on. Yes, that's what I was saying. That there is a YouTubers aren't journalists. I would want to see her journalistic credentials. Anyway, that's it. That's her affidavit. Okay. Here is Graham Cracker's one. Now, remember, he said the reason why it was filed late was because his mother-in-law got ill. You need to remember that, okay? So, I mean, as far as I'm concerned, I haven't seen anything in Katie's affidavit that really convinces me. Okay, so Graham N. Martin. I am the attorney on record for defendants in this matter and make this declaration in the opposition for the default motion of judgment. I have personal knowledge of the facts. For relevant context background, the scheduling order in this case set a deadline for the service of discovery requests as August 5, 2022. The defendants served discovery requests on plaintiffs on August 5, 2022. The plaintiffs in this matter never served any discovery requests on defendants. Let me say again, if you haven't answered, they don't know what they need to. They don't know what they need to file. They don't know what they need to ask for. They don't know. They don't know where she got her information from. Obviously, hello. Prior to August 5, 2022, plaintiffs never contacted me or my office to discuss extending the discovery deadline in this matter. There was no request for a stipulation to do so or even a request for an informal agreement to accept discovery requests following the August 5, 2022 deadline. Similarly, the plaintiffs never filed a motion to extend deadlines in the scheduling order and chose only to request by letter to the court that deadlines be extended. This letter was submitted after the discovery deadline had passed and was the first I heard that the plaintiffs wanted to extend discovery. The exhibits are formatted horribly. The entire article is... Yes, that's right. You can't read it in the entirety. So, and don't forget, in her affidavit, she's written accorded instead of afforded. I would not have thought a journalist would make a huge grammatical error like that. I know a journalist, and they proofread and they check everything. I wrote a letter to the court opposing the deadline extension request, and the court denied the plaintiff's request for the deadline. No, that is not true. It said that request for an extension of deadline had to be filed by motion. So they filed the motion. Don't let the truth stay in the way of a good story. Following the court's denial of plaintiff's request, they said that they... Oh! This is infuriating because we went and we saw on the letter that on both the letter from 7M and the letter from Martin that the court said extension deadlines need to be filed via motion, not via letter. Both parties were told motions had to be filed. So 7M filed the motion. I hope not, Callum and Charlie. So following the court's denial of plaintiff's request to extend the discovery deadline, Counsel for the plaintiff sent me an email on August 25 suggesting that despite discovery deadline had passed, the party should stipulate to extend the discovery deadline so plaintiffs could take several depositions. A true and copy of Amherst St.'s first email dated August 25, 2022 is attached. Later that day, having not procured the deadline extension stipulation she desired, counsel for the plaintiffs sent me another email suggesting that they would be willing to agree to an extended answer deadline in exchange for us stipulating to extend the discovery deadline and amend the scheduling order. Hang on a minute! I thought he said he didn't know. Hang on. They would be willing to agree to an extended answer deadline in exchange for us stipulating, and I thought he said he didn't know about the answer. They said the court hadn't stipulated an answer. And yet here the plaintiffs will say, well, we'll let you have more time to file an answer. Oh, gee whiz. Someone get Mr. Cracker a shovel. A true copy of Amherst St. In response to this second email, that's right. Yes, that's right. That's right. That's right. Well, they have now. I communicated with her that we had already been working on an answer and intended to have it completed and filed in the near future. Those were true representations. The draft of the answer was completed as of the 2nd September 2022 and a true and correct copy. On September 1, Ms. Stackry served a letter on defendants stating that they intentionally were not going to be responding to the defendant's discovery requests. A true and correct copy of that letter is attached to Exhibit 4. True to their word, plaintiffs have yet to provide a single response or objection to any of the defendant's discovery requests because they filed a motion to extend it. Oh, come on! My office responded to Ms. Davitt's letter with an email following day noting that there is no stay of discovery in the case and that they have waived any objections to defendant's discovery requests. Their continued failure to respond to discovery requests would be met with a motion to compel discovery. And that if they insisted on refusing to provide any discovery, they could alleviate their objections by settling or dismissing the case. She replied to my email demanding stipulations not only to the proposed protective order and the injunction, but also to extend the discovery deadline and amend the scheduling order. Her office's increased desperation to manage and obviously this deadline was becoming heavy-handed and included ever more outright demands. To wit, see Ms. David's statement to me in this email for her on the 2nd of September 2022. You want to he wants to talk about desperation? Okay. As I stated before, we are ready to send you discovery immediately upon stipulation to a protective discovery order, stipulation to a temporary restraining order preventing your client from posting about mine until the conclusion of the trial, and a stipulation scheduling order be amended given the court's refusal to call us back in time to schedule a discovery conference, which the scheduling order explicitly required. So I waited a week for the plaintiffs to assess their situation and decide whether to try out any more nuanced approach to the situation rather than the all-or-nothing approach they had been sporting so far. On September 8, 2022, I sent a follow-up email reminding them that their discovery was now late, their objections waived, and their demands for stipulations untimely and unreasonable. Thank you, Kelly and Charlie. I also reminded them that dismissing the suit would fix their discovery problems and offered to stipulate to a limited protective order for the purposes of protecting anything falling under the category of protected health information as defined in law. Well, hang on a minute. Remember, we hadn't had the motion to dismiss at this point in time. This is the point. If she got her motion to dismiss and it had won, all of this would have been a waste of money. Ms. Stackry responded with even more heightened agitation and hostility, suggesting that my office would participate in distributing information received in discovery to the public. I take my professional obligations seriously and have never divulged a single piece of client or case-related information to anyone to whom it's not directed. Miss David's impugning of my character was not helpful in coming to a resolution in this matter. She was referring to your client, mate. I responded that it was unclear whether she would stipulate only to a protective order or if her demand for a stipulation still required an extension of discovery. Amending the scheduling order and stipulating to an injunction. I sent that email on September 9, 2022, and have not received a response to it. Because they filed a motion, you dummy. I'm sorry. This is just infuriating. I don't know how you're feeling, but like I'm wanting just to grab. Like, hello. This is in my opinion, this is a desperate. Oh, they've really tried to. Right, here we go. Throughout the threat of correspondence, Ms. Stagback never once mentioned defendant's answer. The plaintiffs were expecting it. That the plaintiffs did not know the defendant's positions on the issues based on the lack of answer, or that the plaintiffs were intending to file a motion for default judgment if an answer was received. So they're saying he's saying, but they never told us. Here, now, remember I told you to remember mother-in-law, right? Remember mother-in-law, right? As of September 2, 2022, our office had completed the answer and we intended to file and send it that week. Also that week, my father-in-law, who had been in intensive care unit at Mayo since August 5, took a substantial turn for the worse, requiring multiple visits per week from my wife. This left me with a 5-year-old and a 5-month-old to parent and care for on my own for a good portion of September. My father-in-law died on September 26, 2022, after 8 weeks in ICU. I tried to manage my workload and deadlines in addition to caring for my family. The review and filing of our answer slipped through the cracks. Now, I'm really sorry that he's in-law, like we saw in the document before that he said mother-in-law, now it's father-in-law. However, as somebody who's been a single mother, I read this and I want to get the violin out. I have to be honest with you. Like, so what? You know? Well, this is the thing. I can't understand why he doesn't have somebody that. And I don't know what happens over there, but in Australia, you have your little PAs or your legal assistants. They often file the documents. And remember, it's an online submission. These days it's e-filing. So I don't know why he couldn't have uploaded it. So obviously it was a surprise to me. So he said father-in-law here. Where was it? Was it this one where it's talked about mother-in-law? Yeah, it was this one, wasn't it? Yeah, this is it. I think. No, it was the other one, was it? Not sure what they got. I'm just trying to find. Oh, here we go. Here. Here. Look. Second, counsel was unexpectedly called out the office when his mother-in-law became very ill before he could ensure that the answer was properly filed. Martin Declaration. We go to the Martin Declaration and it talks about his father-in-law. So I don't want to be here with semantics. And I can only assume that the declaration is correct because that's been filed under perjury. But if the other document is incorrect, then what else is incorrect? Well, I don't know that he actually either said that. He hasn't communicated. It's also to know deadlines. If I'm the one responsible for them, like, oh, yes. Any attorney admitting they drafted the answer multiple times throughout these several filings is mind-boggling to me. Yes, Bo. I'm really sorry that his father-in-law died and passed, and I understand what it's like to juggle. However, I thought there were other people in the office. Isn't there somebody else that could have taken over the carriage of the file temporarily? Or he writes to the other attorney and says, look, I'm really sorry. This is going to be late. Anyway. So obviously it was a surprise to me when I saw the plaintiffs filed a motion for default judgment without ever having contacted me about the lack of receipt of an answer in this proceeding. As soon as I saw the motion, I went through our file, found the draft answer, and ensured it was completely correct. He filed it and he served it. So he could do it. He did it very quickly once it was. But contemporaneously, I drafted a letter to the state vet explaining the situation with my father-in-law and my belief that the answer had been submitted and served already. I e-served that correspondence. So this was after the event. He should have contacted the court. Anyway. I e-served that correspondence on October 5. So after the event, he's done it. A true and correct copy of my correspondence is attached to Exhibit 7. The plaintiffs have been in receipt of their correspondence and the answers since October 5 and have chosen not to withdraw their motion despite it being moot. Ms. David's office also chose not to respond to the letter. It sounds like he's having a bit of a whine here, isn't it? A bit of a sook. Suki lala. I've received no further correspondence about any of the issues addressed in all of the plaintiff's multitude of motions. You filed through, despite a consistent attempt to resolve those items without motions. Ms. Stavak never attempted to meet or confer with me about the plaintiff's motion for default judgment, despite having been in regular contact with my office since the initiation of this proceeding. Because it was the court that put it on to the docket, not them. The defendants have been diligent in their responses to the plaintiff's requests. No, they haven't. Have met their obligations through these proceedings and corrected the mistake regarding the answers as soon as we were made aware of it. If a death in the family is not good cause for missing filing the answer, I don't know what is. Whoa! Oh, you don't end it like that. If I was the judge, I'd be saying, didn't you have anyone else in your office that could do it? What happened to all of his other cases? Did they all sit there for a month, or did he give them out to other people? Okay, so here's Exhibit 1. Graham, I'm not sure if you received an order on the motion to dismiss yet, but I would recommend that we agree on a stipulated discovery plan, extending discovery deadlines, and requesting an extended scheduling order. I anticipate we'll need several depositions in this matter, and I wouldn't want to force everyone to rush to push this through. And he's gone, good afternoon, Amber. Thanks for getting in touch. Oh, I think so. And says, good afternoon, Amber. Thanks for getting in touch. Now, actually, if you notice, good afternoon, Amber is in black. The rest is in red. A number of times since this case began, you have asserted that we agreed that neither party would talk about other publicly during the pendency of this case. But I reviewed our email correspondence, and the only thing we agreed to do was not disclose online contact information of the parties or their attorneys. If you have a different written agreement than what I have just described, will you please send a copy of it through so I can review it and advise my client of it? I don't think such a thing exists, though I'm unsure of the continued insistence that my client is violating it. I appreciate the reach out about the other matters and will discuss it with my clients and get back to you in a timely manner. Thanks again. I hope you well. Otherwise, have a good one. And that's right. She went on a rant about how they, yeah. Okay, meet and confer. Thanks, Graham. I will discuss settlement with my client and see what they are open to. As stated in my previous email, unless we can stipulate to a protective order, we will be moving forward, and I plan on filing that motion this afternoon. I'm not sure how much your clients would suspend on an answer, but we could be open to an agreement to extend the answer deadline pending settlement if we can stipulate to a discovery extension and simultaneously request the court for an amended scheduling order. They've just offered a settlement. They've just offered a branch for settlement there. Good morning, Amber. We're in receipt of the order. We have reviewed it with our clients and are considering the impact of this case. As to your contention, I understand why you are seeking a stipulation to extend discover, but I'm not sure that my client needs any depositions in this matter. We have issued our timely discovery requests relevant to the issues your clients raised. We are awaiting timely responses to those requests. We do not need that deadline extended. If your clients would like to discuss settlement instead at this juncture, I think it would be fruitful. I will discuss your request with my client and follow up with a final response on that front, but I think in the meantime it would be best if we discussed methods of disposing of this case and saving everyone a lot of money. So they're talking, the lawyers are talking settlement sent via superhuman. Via superhuman. Oh, it would be don't talk about us again. And she knows that she can make money from it. Hi, Amber. My client remains disinterested in the proposed stipulations. We're already working on the answer, and we'll have one filed in the next week or so. I didn't see a directive as to when the court expects it to be filed, so absent such a directive, we'll just create and file it with all deliberate speed. He's essentially, in my opinion, he's contradicted his stuff. Dear Ms. Hendrick and Mr. Martin, on August 26, 2022, we filed a motion for protective discovery order in this case. The motion was filed due to the sensitive nature of the documents being requested by defendant. We will not respond to any discovery requests until an order has been issued on the aforementioned motion. Again, they've said we're not going to talk about it until the court's decided. How can you be sooking over that anyway? Good afternoon, Amber. We are in receipt of your letter issued yesterday and are surprised that your clients intend to deliberately not meet their discovery obligations. There is no stay of discovery in this case. No, is it really weird that the font's different? Like, it's like, from what I can see, it looks like someone else has written it and it's just been a copy and paste job based on the fact that good afternoon, Amber, we are a receipt, and then all the rest is written there. But anyway. Nor is there any imminent decision on your motions, given that you have yet to even schedule those hearings. Hang on, the court schedules the hearings. Your client have demanded relief outside what is available under the rules, but hasn't even managed to schedule hearings on the motions requesting that relief. There is no relief on the horizon of the sort you have requested, and therefore absolutely no basis for that sort of delay you have stated your clients intend to unilaterally impose. What on earth? Whoa, talking about gobbledygook. Regardless of whether your clients would prefer to abstain from discovery and regardless of their positions on the scheduling order in this case, under Minnesota rules, their discovery responses are due Tuesday. Based on your... Hang on! hang on a minute. He was saying that they didn't notify them until after. This email is saying that their discovery responses are due on Tuesday, and he's just contradicted himself. It says their discovery responses are due Tuesday, but he said in his affidavit that they didn't make contact until after the deadline had passed. Based on your letter, we understand that your client intends to miss that deadline deliberately and without any cognizable legal basis to execute their failure. Notably, a party's failure to timely respond to interrogatories or make objections waives all objections except those related to privileged work product and experts' conclusions. He's just contradicted himself. Please confirm that we'll receive the discovery responses no later than this coming Tuesday, or we will move to compel, seek our fees incurred in doing so, argue that your client has waived any objections and seek relief. But she's just said that they filed for a protective order. Alternatively, should your clients prefer not to engage in discovery in this matter, they can choose to dismiss their case with prejudice, at which point their discovery obligations will cease. If they choose this course, please inform us of that choice prior to Wednesday, the 7th of September, so we can forego incurring expenses and bring in a motion to compel discovery. Is this guy dense? That's right, they haven't answered. So it says, Mr. Martin, our office has been attempting to contact the court almost daily since the scheduling order was sent out. I had my paralegal call the day we filed the motion, as well as today, to attempt to obtain a hearing date regarding the motion which was filed. Pursuant to the scheduling order, the court was supposed to settle all requests via a scheduling conference. As Judge Davis has been out on leave, this will occur. Your frustrations with my office should be directed towards the court. I am just as upset by my inability to obtain a call or email back from the court to schedule anything. I have attached an email from my paralegal with her latest correspondence to the court, their responses, and her statement that she did in fact call the court again this morning to attempt to schedule a hearing date. I just read the next line. Your client has a history of doxing people on the internet. Your client has a history of doxing people on the internet, displaying documents obtained during the discovery process on their social media handles, and misconstruing the contents of documents she posts. This entire case is based on your client's egregious behaviour. As such, our requests that your client not be allowed to post medical records, leases, and sensitive financial documents on the internet is appropriate. In your requests, you ask for highly sensitive information. No reasonable person would want shared with a stranger, let alone the entire internet. Boom, tish. As I stated before, we are ready to send you discovery immediately upon stipulation to a protective order. Stipulation to a temporary restraining order preventing your client from posting about mine until the conclusion of this trial, and the stipulation with the scheduling order be amended, given the court's refusal to call us back in time to schedule a discovery conference with the scheduling order explicitly required. None of these requests are unreasonable or unreasonable in this case. I'd like to stipulate to the above. I will retract my motions. If you would like to stipulate to the above, I will retract my motions so we can have discovery to you next week. I'll be unavailable until Tuesday as I'm leaving town for the long weekend. So she has stated that if you agree to that, you can have all the information next week. They haven't. He was implying in his stuff that she was unreasonable. Good afternoon, Amber. I've read all your correspondence and we understand you and your client's positions on issues currently before the court. We are of the opinion that the proper time to ask us to either stipulate to extending the scheduling order deadlines or make a motion to do so was prior to the deadline expiring. Well, they did. We do not know why your office chose not to come to us directly to discuss extending the deadline. They did. We do not know why your office chose to seemingly engage in this ex parte communication with the court to try and extend the deadline. Whatever the case, that time to handle this by stipulation or by motion was prior to August 5. It is now September 8 and your discovery is overdue. Per the rules, your clients have waived their objections to our requests. We understand your clients that some of the information we requested is potentially sensitive. The information also is directly relevant to the claims your clients have made in their suit, so it's necessary and needs to be disclosed, regardless of the existence of a protective order. If any information needs to be included in any motion, documents, or other court filings, we will absolutely comply with our redaction responsibilities, as well as any other obligations to keep documents confidential under laws and rules. However, the only way to get out of producing information and documents relevant to the claims and defences in this lawsuit is for your clients to dismiss the suit. Absent such a dismissal, your clients are obliged to meet their discovery deadlines obligations under the rules. If they wanted a protective order in place prior to the deadline for producing their responses, any time since serving the summons and complaint would have been a good time to do so. Waiting until the discovery deadline and using the lack of protective order as a shield for not producing discovery is not allowed in the rules. Please complete responses and documents by the end of the day on Tuesday, September 13, or we'll file a motion to compel discovery. If you are willing to commit in writing to providing your documents by that date, I will enter a stipulation to a limited protective order for anything that would be considered protected health information under the law. Any stipulation would be only for that purpose, though, and not for any other items your clients demand. Oh, she's got him by Mr. Martin. I will not be sending discovery to your office absent a rule for our motion for protective order. I do not trust that information sent to your office will remain in your possession, especially given your refusal to stipulate to a simple agreement that your client not post about my clients or share information obtained to discover with third parties. Given the egregious nature of the allegations your client has made about mine and her involvement with an up-and-coming Netflix documentary about my clients, I think it's more than reasonable that all documents and discovery in this matter be contained. She's got more information about what KJ's up to than what he has. They've worked out that she wants everything for the Netflix documentary. If you'd like to discuss a reasonable stipulation regarding the motions I've made, I'm willing to discuss. If you feel it necessary to file a motion to compel when I've stated I will send you discovery to you immediately upon the stipulation to protect discovery, then that is yours to make. I think she's running rings around him. I think. That's my opinion. She's absolutely running rings around him. Hi, Amber. I have not impunged your character or questioned your professional integrity, and I would appreciate it if you do likewise. I'm under any number of professional... Oh, I don't know. Doesn't matter. The thing is, Mr. Cracker, she was talking about your client, not you. I'm under any number of professional obligations not to disgorge information obtained during discovery, and I do not intend to do so in this case or any other. As for your statement about the necessity of our potential motion to compel discovery, you've now issued conflicting statements. Please clarify which of these statements. Please clarify for me which of these is the correct statement at this time. You'll provide discovery upon stipulation to protective order only, or you'll provide discovery upon stipulation to a protective order, an injunction, and essentially discovery deadline. Your most recent email suggested that your position has changed to statement A, while prior today it was statement B. I'd like to know what you are requesting and proposing so I can help my clients assess your proposal with clarity. Look at some documentary, right? Yeah. So this is the default judgment letter, which we here, this is the letter. So we're receiving your motion for default judgment in the 7M case, Rule 5501 of the Minnesota Legal Private we're a party against whom a judgment for affirmative relief is filed to plead. We have been engaged on the other side of this suit since it was filed. There have been appearances made. I don't know. We have engaged, we responded to the motion which constitutes a messenger of defence under Rule 12.2. I'm aware that the answer is due in this matter, despite there having been a deadline for one issued by the court. I believed that one had been sent to you already. It was drafted shortly after the order came back denying our motion to dismiss. At the time our answer was drafted, my father-in-law was in ICU. He continued to be in ICU for a total of 8 weeks until September 26 when he died. Perhaps it is understandable to you that this has caused some level of upset in my personal life and made things chaotic as usual. Please find, filed, and sent alongside this letter a copy of the answer we drafted and that I thought it had been sent last month. Given our typical matter of correspondence with you without delay, if you wanted an answer and had not received it, I would have thought a simple email request would be sufficient. But Mr. Cracker, you had already said, if you couldn't file an answer, how would you have responded to emails? Now I need to respond to the court to explain that your motion is moot or you can withdraw it. Whatever the case, you have your answer. You know my client's positions on these issues and default is inappropriate. Please advise whether we should spend our resources unnecessarily in responding to a moot motion. Funny, I've heard the phrase moot motion by somebody else, for which there is no basis in the first place. If you choose not to withdraw your motion, I will discuss with Ms. Paulson whether she'd like to seek her costs or other appropriate sanctions for the misuse of resources and the abuse of the litigation process. Oh, and there you go. So that's everything that's been filed in that matter. So there you go. What are your thoughts? There are lots of mistakes in there. Lots of mistakes in there. It's not very professional in my opinion. Not very professional in my opinion. But, you know. But I'm just a learner lawyer. And we get... Yeah, that's what... I mean, they're trying to... They've kept trying to portray the fact that they need... they're really trying to get it so that they drop it. How many times did they say dismiss it, dismiss it, dismiss it? Anyway, that's all the legal documents. So I'll be surprised. Look, they may get a protection order, but if I think they might get some sort of protection order, but I don't think all of it will be done. I think discovery. I think that there will be a new discovery deadline done. I think I can see the judge saying, "You two go sort it out yourselves. Yeah, come back to me with a new timeline." Because judges don't like being put in the middle of these types of. I mean, that's what happened if you remember in the Chris Lee Paulson case. Remember, KJ hadn't responded to discovery, and the judge said, "Go to a private room, have a discussion, come back to me." And I could see the same thing happening here. So I don't want their time wasted. We've got better things to do. Anyway, I want to thank you for joining me and going through that. There was some, as I said, there were some really funny moments in that. The 21st of November is when it's all happening. And as I said, my issue is, I think the biggest hurdle they've got to overcome is that the court automatically put the default judgment hearing in. The court's the one that's done it, not 7M. And I think it was so crazy. It was entertaining. I know, Bo. It was entertaining. I have to say, you can see why I was laughing my head off on the train. I mean, her I didn't actually get past her affidavit. I was just laughing. I couldn't get past celebrity news journalists. I just was laughing my little head off. And everybody was had no idea what I was laughing at. Oh dear, that was sad. Let me just pull up this and we'll just make sure that I've got the dates correct because I don't want to give you wrong information. Oh, is that right before Thanksgiving? Well, someone might have something to be thankful for. I'm not sure how she can keep bringing Shekinah Church in when they're not actually suing. So here we go. We've got a motion hearing on the 21st of the 11th. So that's when all the motions are going to be heard, and a default hearing on the 21st of the 11th. So it will be up to the judge whether she hears all the motions first or whether she hears all the. So this proposed law that just says that the motion to compel goes and that the protective order fails. But there's been a lot filed. And it's interesting that she's got 3 lawyers. Here's the other issue that I've got. She's had 2 lawyers on file. She's now got 3 lawyers on file, right, on her list. And they still couldn't file the answer on time, okay? She had 2. 7M and Shin and the Derricks have got 1 lawyer on file. And who's been on the ball? I don't know. I can't work it out. So, 21st of November. But if you've got multiple lawyers, I don't know how one person having a personal crisis affects the others from stepping in and doing the job. That's just my opinion. Just my opinion. Anyway, I want to thank you for joining me. Thank you. It's really good to see you all. I have to, not exactly. I have to do what's called a PRT, practical learning training. It's like an internship for a year, and then you have to apply to the court. So it's where you can get real life experience. There'll be exams and stuff like that, but it's not the bar exam. If I want to become a barrister, I have to sit some more exams and stuff. But just to do everyday lawyering, no, I don't need to. And COVID changed a lot of those rules as well, and I think for some of them have been changed for the better. All right, well, I thank you for joining me, and I'll catch you again next time. Until next time, bye for now.